Hello again, everybody, and welcome back to the Gaming News Canada show. As always, I'm your host, Steve McAllister. When Ontario's regulated sports betting and igaming industry opened back in April 2022, operators weren't allowed to offer fantasy sports and online pokers and other games that essentially cross borders. There have been efforts since then and ongoing actually right now to change that and give operators the opportunity in Ontario to essentially once again offer online poker, fantasy sports, and other peer-to-peer games outside of Ontario borders. And so we wanted to get to the most learned expert on the topic and bring us up to speed on what's going on. And we're probably going to ask him to put on his legal robes for at least a few minutes in this conversation. So we welcome back to the podcast Paul Burns, the president and CEO of the Canadian Gaming Association. Paul, as soon as you mentioned legal, I know our listeners' eyes might glaze over. I believe you and our eyes are glazing over, but we do know there is a case ongoing right now, and I'm hoping maybe you can boil it down to layman's terms and bring our listeners up to speed on what's going on.
Yeah, I'm happy to do that, and thanks for having me again, Steve. It wasn't just one slight correction that poker and the fantasy were allowed to be offered. It's just what made it unfeasible to do so was those two products in particular require a lot of liquidity in the pool, a large pool of players to make it economically viable. And one of the features that Ontario's marketplace lacked was the use of international liquidity. It's something that had been part of, obviously it's part of the gray market, but it was something that the Ontario government hadn't determined when the Ontario market began, that international liquidity would not be permitted because they were uncertain about doing so would be consistent with the criminal code. And so since April of 2022, we had been active in discussions with the Attorney General, his office, and officials on how we could get the issue of international liquidity sorted out once and for all. And through a lot of internal work through the Attorney General and the ministry, their solution was to actually put a reference question to the Ontario Court of Appeal. So earlier this year, they put the question in the form of an order in council passed by government that stated, would legal online gaming and sports betting remain lawful under the criminal code if users were permitted to participate in games and betting involving individuals outside of Canada as described in the schedule? Well, the schedule talks about the framework that Ontario created. And so what they've done is gone to the Ontario Court of Appeal to get clarity on what they would need to do, if they can, to allow international liquidity in the Ontario marketplace. And it's a question that when someone goes back, and as I said, I'll only pretend to be a lawyer right now, but it was the question of including people in the regulated marketplace in Ontario, in Canada, and outside of Canada, I should say, and playing games with people from the Ontario regulated marketplace with people outside. And the channel, really what happens is that the Ontario players would never leave the regulated marketplace in Ontario. And the fact that there's a number of mechanisms and ways in which this occurs, because there's jurisdictions in Europe and the United States that have liquidity pools. So they have agreements, and that's like France and Spain in Europe. There's a 6-state compact in the U.S. For things like poker and other games. And so there's precedent, and then there's, so needing to get some clarity from the court is really what this was designed to do, and to hopefully bring back some level of international liquidity. And the guidance that the court is really, we're seeking from the court, and the province is seeking, is just how best they would do that. And and so that's the measure that's there. We, as the CGA, applied to as intervener status on behalf of the industry to represent the interests of the industry in seeking this. Other parties, obviously, it's very particular for the poker, which has seen a pretty strong decline without international liquidity in Ontario. And then daily fantasy would obviously be part of that too, that require large pools of players. And the Minister Downey has been quite forthright in saying that they were working on it over the years, and earlier this year he moved forward with the order in council. And so there's been some preliminary hearings, but the actual hearing itself in front of a panel of the judges of the Court of Appeal will occur in late November, where the Ontario government has laid out their reasoning and evidence on why they think this is a something that what they're seeking, and some history and insights on how liquidity could work and options, so the court could consider that, and also consider some of the historical considerations that the gaming sections of the criminal code, when they're debated in the late 60s, that the parliamentarians in their debates even talked about whether the ability to deal with foreign lottery schemes and things like that at the time. So it's been an insightful process. It's a lot more exciting for lawyers than it is for you and I, probably, Steve. But it's something necessary that we see as ways of trying to really help kids, for customers, especially those who like to play poker online. And as we know, that was a big part of the Ontario marketplace, who have seen their the ability to get games and get the types of games they want to play has been impacted by the lack of liquidity. And so it looks at, in other daily fantasy and other pool related sport products have been impacted. So this was, I think, the best way for the province of Ontario to go forward. And we've, I think, laid out a very compelling case, as the province has, in terms of why it's something they can seek. And the fact that really what comes down to it is that Ontario players will always be protected by the Ontario regulatory regime in a scheme like this. And so that's where we are right now with the question itself. It's a very narrow question, but it's an important to get the interpretation from the court, so the province can then decide what guidance they would need from the court, if the court offers them any. You need to create a liquidity market.
Yeah, Jack Tadman from GME Law will join us later in the podcast, and we'll let a real lawyer kind of walk us through the legalese, Paul. But I remember when the market opened 2.5 years ago. At that time, because there was no liquidity, it really smaller. My understanding was there were a lot of smaller players in the daily fantasy sports space who just couldn't see paying the application fee to the AGCO and then spending the money to operate in Ontario. So I guess you could suggest that there was a missed opportunity there. And as you pointed out, I think it's always been accepted that if you were playing online poker or in daily fantasy sports, it didn't matter if you lived in Leaside or Tallahassee. You were just playing games against like-minded poker players or sports fans.
That's right. And what you for companies like the daily fantasy business particularly was severely impacted. Like even FanDuel and DraftKings ceased to offer daily fantasy products to their customers in Ontario at that time. And it wasn't because daily fantasy is regulated under the sports betting and igaming regime in Ontario. That they, because of the lack of liquidity, chose not to make it part of their product offering because it's limited to players in Ontario. And I know that there was a number of Ontario-based daily fantasy operators that were also impacted, and it was unfortunate. But the province didn't feel comfortable moving forward without at that point that it wasn't clear to them under the code, and they've chosen this path to get clarity. And so, because they want to make sure the public interest is still protected in this, and understanding how liquidity markets have been created in other parts of the world has been insightful. So through this process, we'll get getting the court to provide clarity on how they see it under the criminal code is important to move forward. So I think it's the Attorney General has been a great champion of this exercise. I know it's not terribly sexy, but it has been an important part to operators who want to, especially the poker operators like GGPoker and PokerStars in the marketplace.
Paul, do you anticipate, will there be any other, I think the latest hearing or whatever you want to call it, where the Court of Appeal took place on July 16th. Do you expect any other proceedings up to November?
At this point, we don't. We have there are a number of parties that have sought intervener status at this point in time, and most of which are concerned with from obviously the poker companies and ourselves on behalf of the industry, and understanding that understanding and educating and being there to support the province of Ontario and thereafter, but also understand how liquidity markets can work, and they participate in.
Yeah, and this is a topic that we've also Digger Turnbull from the Fantasy Sports and Gaming Association. We've had Digger on the show in the past, and we'll get Digger back on when we get some type of decision in November. But obviously, this is a situation that the FSGA has been following very closely because it affects the membership there.
It does very much so, and I've had a number of conversations, and Digger was helpful to the Canadian Gaming Association, and as we put together our affidavit on behalf of the gaming industry. And so, no, I think it's they were pretty severely impacted through this decision, and so as a sector, and so obviously would like to see clarity. And I think Minister Downey has recognized that the from the daily fantasy industry was quite vocal in getting to him and asking for his help, and so I know he's he found the best route for the Attorney General to get clarity under the law. And so that's so we're in that process now. It's unfortunately going to take a few more months, but we'll get an outcome either later November or early 25.
Paul, I think it's important to mention, just for people who don't work in the gambling industry or aren't familiar with regulated industries, that these types of issues, these are things that happen in an evolving market. And I think it's important to remember again that the Ontario market came together very, very quickly. I think Bill C-218 was passed in August 2021. The Ontario market opened in April 2022, and we had Martha Otten on the podcast during the Canadian Gaming Summit last month, and Martha talked about what a fast-moving train it had been to get the market up and running, and that IGO itself now continues to evolve and continues to change, and is working hard to kind of get up to speed in other areas like data, merging data, for example. And I think what we're seeing here is this is a case of a market that's still very young.
Well, we are exactly, Steve. But we're the other, and what this reference question highlights is we're doing this with the overriding legislation in Canada is in the criminal code, and it's arcane. And the reality is it has not kept pace with the pace of the gaming industry, of consumer preferences, of technology. And so trying to the phrase conduct and manage means a lot of different things to a lot of people. There's 6 or 7 different versions of it being applied in Canada today. There isn't one of anything. It's interpretations. And particularly the federal parliament was intentional in wanting the provinces, especially with the 85 amendments, was intentional for the provinces to decide an interpretation and let them determine what's best for their jurisdictions. But in this, some people have tried to project things what they believe onto others, and we've had a situation where IGO went to court with a question and a challenge from the Mohawk Council of Kahnawà, where we did finally get some very strong language in terms of from a court and on the issue of conduct and manage, because there has been very few cases, very little case law written about conduct and manage in Canada. But with that decision, a lot more latitude than some may believe they had in how they can create a conduct and manage regime and what it is. And I think that's been very important. But the challenge of all of this stuff is, Steve, for everybody has been that we're dealing with a very arcane criminal code section when it comes to gaming. I would contend that I don't know if it's even merits belonging in the criminal code anymore in the form it does. But the reality is it's there, and that's where unfortunately we have going through processes like this that take time, but also get courts provide clarity and provide decisions on which then helps base and other jurisdictions can actually benefit from. For liquidity, international liquidity, like for a lottery, for example, to participate in a world lottery, if the province of Ontario wanted to join Powerball at the end of the day in the U.S., if this decision of permitting liquidity like that, then they could do these things. So it's also provide clarity and providing opportunity for greater product offering for customers. And so there's a lot of benefits in getting clarity on these things as well, because as we all know, amending the criminal code isn't an easy exercise and it doesn't come quickly.
Paul, there couldn't be a more perfect segue to the other topic we want to talk to you about today. And again, this landed on my desk this morning. We're recording this podcast on Monday, July 22nd. Paul, I think I reached out to you on Friday before the weekend to see if you'd join us to talk about the court case. But Michael McCarthy, the longtime sports media, sports business reporter, now working for Front Office Sports, had a piece that landed on Sunday about concerns about the criminal code and match fixing in Canada. And McCarthy used the Jonte Porter case as kind of a bit of a jumping off point, which I think that might have been a bit of an overreach. But Mike did speak with Danielle Bush, senior counsel of McCarthy Tetro, who we're both very familiar with, that Canadian lawmakers needed to get their act together and pass something more specific with regards to match fixing. And again, this is a topic that you and I have talked about on several occasions. But again, just great serendipitous timing for this article appear. And I think, Paul, it just gives you a chance to reiterate the stance that the Canadian Gaming Association has taken on the criminal code and match fixing.
Yeah, it was an interesting article. I look at it a little differently than Mike may have in some respects, because in fact what we've seen is that prior to C218, nobody was watching anything, right? Let's be frank, that was exactly what was occurring and what we've seen since. And because of the expansion in the United States, North America has created where there was none 7-8 years ago in terms of regulatory oversight and monitoring and watching. Now there's quite a bit, and it's like history, it's experience that other jurisdictions around the world have seen. When you start to monitor and watch, you find things. And in the leagues and players and athletes, and there's been good efforts for player education, and about the roles and the rules around what they can and can't do when it comes to the sport and their betting. Unfortunately, some haven't listened as well as others. But what we've seen is that the system is flagging and catching, and through suspicious betting patterns and other things that operators see, working with monitoring services like the International Betting Integrity Association, IC360. There's a very robust regime in place. And when it comes to Canada, there was case law which, because I was quoted and I've had my words thrown back at me in C218 when in the previous iteration of the sports betting bill, which was then Bill C290 in 2011, 2012, I did say quite clearly to the Senate and to the House of Commons, there were no measurable laws that could be pointed to say this will deal with max fishing 100% guaranteed. What happened was in 2015, there was the sections of the code that everybody referred to were tested. And it was a Riseborough case, as it's known as. It went to the Supreme Court. The AGCO was successful in that the Supreme Court upheld the use of the sections of code around fraud and around, fixing matches was upheld. And so it gave case law, finally, to that people could point to and say, yes, there is a measurable now activity, a law that we can point to, and we can attack this issue. But that doesn't mean we need to stop and say everything's done. And that's where we've supported the Canadian Centre for Ethics in Sport. We think that the federal government does have a role, and we've been active in the conversations around the Macallan Convention of the Council of Europe on match manipulation and athletes, and the international convention that countries are free to sign, and Canada could take the steps to become a signatory. In fact, there's the process of becoming a signatory is not it's robust. It requires a number of activities, and some often best performed at the federal level in terms of coordinating an integrity body. The Ontario AGCO, when they created the Ontario sports betting regulations, created them to be consistent with the Macallan Convention in the effort, in the attempt, and one day maybe somebody would want to have the Canada become a signatory. So there was a lot of good work that's been done, and you've seen it from the AGCO calling out the UFC to enhance their own internal policies, to removing the WBA and the boxing, their boxing matches from sportsbooks in Ontario because of concerns over the lack of an insider betting policy, to John Tay Porter, where we know at this point in time that we know there's an OPP investigation. So to say that there's that we need to, nothing's happening and is just not right. There's lots happening and there's lots occurring. Do we need to do more? Yeah, sure we do. And I think that's the exercise in here. It's in improving athlete education, and you've seen that. The International Betting Integrity Association is doing athlete training with Professional Footballers Association, the Canadian Premier League Players Association. The CFL has done a great deal of training with their players. It's starting. It's great. And, I think the federal government, instead of talking about ways to intrude in provincial jurisdiction about advertising, should be actually spending more of their time talking about how they can become signatories to the Macallan Convention.
Paul, what do you say, to the people out there, and Declan Hill's quoted in the McCarthy article, when people say that it's the sports betting ads now, like, betting logos on hockey players' helmets and all this betting that's available, that makes match fixing inevitable. What's your response to when people say that?
I think linking advertising into players match fixing it's just I don't it's a nice catchy line in this day and age because everybody's concerned about advertising. The reality is that if we don't have regulated betting, then you don't have anybody watching, and that's it. It's the fact that you have robust regulatory oversight over sports wagering in your jurisdictions. Why is Ontario the only jurisdiction that has taken the WBA off their? Why were they the first ones to call out the UFC? They created a regulatory regime and they're acting on it, and that's what we wanted. Because before, they only oversee regulated gaming. So to say that nothing happened, well, it doesn't mean anything was going on. And there's lots of stories, and Steve, in the North American sports betting and other levels of sports within North America, at the college level and others, where there were concerns over player behavior or match fixing. And I think that's why bringing it into the open, providing education tools for players, assistance for players, because there's been some horrific stories, especially at the NCAA Division II level, where players become almost captors of the organized crime rings on match fixing, because the players are then, once they've started, they've kind of caught in and they don't want to get called out or reported by, and then there's threats from the organized crime organization. That's been going on. And that's where, yes, giving tools to athletes to be able to blow the whistle and say, hey, something's happened here and I need help. Yes, let's look at it from that point of view. And I think that, but advertising didn't create it. And we've known there's been betting scandals long before there was regulated sports betting in North America. But now we have better tools. We have better education. We have better levels of oversight that we have now in place. And that's the important part to look at. It's, everybody can, when you say the sky is falling long enough and eventually does, well, then you can say you're right once, every once in a while. But, the blind squirrel always does find a nut every now and again. And I'm like, you know what? We have to support efforts on all fronts. And that's why expansion of regulated sports betting across Canada, in terms of more, because there's a lot still happening outside regulated markets. But we also need to make sure that everybody's coordinating. And that's where the CCS is, because of their strong connection to athletes and protecting athletes, getting the resources, but getting that commitment and training. I did a lot of work early on with Earl Cochran from Canada Soccer. And Earl was fantastic in leading with Canada Soccer, because FIFA and CONCACAF, and for all the warts everybody have about those organizations, they took this issue very seriously. And we did a meeting in advance of the Women's World Cup. It was about a decade ago now, and brought Interpol's match fixing unit that FIFA helped fund to Ottawa to meet with law enforcement and government officials. And people in the room didn't understand what was going on, because there was no regulated betting. They didn't understand that the Canadian soccer leagues, as a semi-professional league, was the captor of match fixers. But there were, because it's a trans-border activity, that a match played in one country, bets placed in another, and the match fixer in a third. It's a very difficult to prosecute and to convict. And so you need the best tools you can find. And we're all in favor of that. But, other countries like Australia and others, the first step in a lot of this is creating regulated betting markets. Then you can begin to put the tools around that. And that's what we've done. And so we're off to a good start. Just one more. It's the Bill C-218. There was an observation attached to that bill by the Senate that the federal government, asking the federal government that they should investigate and pursue Canada becoming a signatory to the Macallan Convention.
Right.
And so, that was recognized in the Senate at that time. And there was a few senators that were very impassioned about seeing that happen. And that's the observation was added to the bill. Because you need to create the regulated marketplaces. Then you can start to build the framework around them that creates the framework for integrity.
Yeah, I'll just point out too, Paul, the International Betting Integrity Association, which has a relationship with the Canadian Gaming Association, put out their second quarter 2024 integrity report over the weekend. And again, no cases of suspicious betting activity in Canada. And again, I think ABIA is pretty thorough when it comes to monitoring that activity and working with other companies that monitor activity as well. So take that for what you want.
There's a great level of monitoring going on, and by all of the parties working together with regulators, integrity monitors, and the sports books themselves, and with the athletic community, the leagues and others. There's strong levels of partnerships have been built I know the AGCO has worked very hard at their level to do that, and I think it's been tremendous.
Hey, Paul, before I let you go, just two quick things, somewhat related to betting by athletes. And Shane Pinto, the Ottawa Senators forward, who was suspended for 41 games last season, came out last week and told everybody that it was proxy betting. He was living in Canada playing hockey. He had buddies back in the U.S. where he's from placing bets for him, and that's not allowed. And again, I find it's for me, it's a head scratcher, and this is a horse I've been beating over and over again now. Why the NHL wasn't transparent about this? And to me, this is a bit, nothing burger might be too strong a word, but this is much different than the guy who was betting on hockey games or betting on his own team or betting on himself. And it just makes me wonder again why the NHL wasn't transparent when they announced Pinto's suspension at the start of last season.
I was puzzled at his comments at this point in time and juncture, to be blunt. I understand there was whatever agreement he made with the league and the rest. It does point to, but this is where player education becomes exceptionally important, because you need to have players understand the rules and what they can and can't do. And I think what he definitely served was, because in talking to many in the NHL community around this time, is not players understanding, how did they know? Well, everybody monitors your accounts because they know who you are, because you're a professional sports athlete, you're flagged in the system. And in some cases, in jurisdictions, it's mandatory that happens, and others you may not be able to bet depending on where you live. But the point is that it still shows the need, and that continuous need for them to understand what you can and can't do. And I think it's unfortunate for the players it happens to, is that I don't think it's on the league's part for lack of notification, but they have to understand what the rules are. And I think it's clear, and you ask yourself, do you really need to bet on sports? When you're playing a professional athlete, and there's maybe just something you don't do. I mean, anybody who works in a casino can't gamble in the place they work. So it's, the people have rules, and workplaces have rules. And so I know that the leagues try their best not to limit player freedoms and other things like that. But at the same time, it's pretty simple that you just stay away from these activities. And so I was puzzled by his need to talk about it, to be blunt, at this point in time. But he felt the need to talk about what he was doing, and what he was doing was clearly not right.
Hey, let's end the segment on a bit of a lighter note. It's been, I think the Canadian Gaming Summit was a large success once again. So congratulations to you and SBC and everybody involved in organizing last month's event in Toronto. And then you've announced two new members to the CGA. Play and Go came on board, I think, just right before the summit. And then last week, the CGA announced that Kieran Interactive is on board now as well. Yeah,
membership continues to grow. It's been awesome. The summit was fantastic. A good increase in attendance this year over last. I think it was a very great educational sessions, great networking opportunities. The SBC team did a wonderful job, and coming back to Toronto for again next year. And we're looking forward to that. And with Kieran is amazing. I'm going to have some virtual sports products that are really cool. And I know they're getting a lot of interest in the marketplace. And we've also added the innovation group as a member of the CGA, and more to come. So it's been a great time for us. The summit was always a great occasion. It's a bit of like a family reunion, as I like to call it, and getting everybody together. We had Minister Nally from Alberta come to talk about their plans, and Minister Downey obviously coming to to share some remarks about the Ontario experience. And I had the occasion to walk around the trade floor with Ontario's new tourism and gaming minister, Minister Stan Cho, who is really excited about getting into his portfolio. So, it was a great opportunity for a lot of people to come together, and between the crowns and operators and suppliers, I was a tremendous 3 days. And so it's always good to build upon, and it's nice to have everybody in one place for a little bit to connect and to network and catch up.
Paul Burns is the president and CEO of the Canadian Gaming Association. Paul, I'm glad you're not a lawyer, because we always say we're going to have you on for 20 minutes, and then we end up going much longer. So the billable hours would break our guest budget if we did it that way. But anyways, always appreciative of how generous you are with your time.
Thanks,
Paul.
Appreciate it, and happy to do it anytime.
Yeah, enjoy the rest of the summer. We'll try not to bother you until after Labor Day. Okay. We now welcome to the Gaming News Canada show the managing partner, chief legal beagle, head honcho, Jack Tadman of GME Law to the show. Hey, Jack, thanks so much for joining us and being with us once again.
Yeah, thanks, Steve. Thanks for having me.
Hey, Jack, I wanted just to follow up on the earlier conversation with Paul Burns from the Canadian Gaming Association, and I know you're following this liquidity case for the Ontario Court of Appeal as well. And I'd just like to get your thoughts from a legal perspective in terms of the background and context of this case, why this case matters. And as Paul was discussing earlier, this is an important case for operators, not just operators in Ontario, but again, as I mentioned to Paul, we know that online poker players and daily fantasy sports, that there really have tended not to be any boundaries, and it doesn't matter, if you're playing an NFL pool, you don't really care if someone's in Kingsville, Ontario, or living in Grand Rapids, Michigan. They're just sports fans who want to engage in a fantasy sports game. But I know you've been following this case, so I'd love to get your perspective on it.
Yeah, for sure. I mean, you've alluded to it, but let's just talk for a minute or two about why this matters. I mean, obviously, it's good for the operators, especially those providing games where shared liquidity is necessary, but it really does benefit players. The Ontario iGaming market launched in 2022. It was a ring-fenced market, no liquidity sharing. And really that affected three verticals: poker, DFS, daily fantasy sports, and progressive jackpots. Of those three verticals, I think DFS was the most significantly impacted. I mean, it was because there was no way in the registered Ontario market, regulated Ontario market, to play DFS. I mean, poker is still not great here, but at least there's a handful of registered operators who are offering poker, and progressive jackpots still exist, but can't be combined with other jurisdictions. So, the regulated market, it didn't kill DFS, but it did force players who want to play DFS to use unregistered operators, and they still exist. They're still offering daily fantasy in Ontario. So FanDuel and DraftKings, the two largest DFS operators, they got the Ontario registrations, but they chose not to continue. And other operators, successful operators like Sleeper and Underdog and others, stopped offering the product just to comply with the requirements of not offering services to the Ontario market. So, for DFS players, they got the Ontario screw job. For years, the operators have been saying, "Oh, don't worry, it's a game of skill. DFS is a game of skill," and in many states it is. Maybe it is in Canada. Who knows? But the AGCO took the perspective, based on legal advice received, that they have jurisdiction over DFS. So that's where we're at. But I do feel badly for DFS players. There's no business case to have DFS. At least the operators have determined there's no business case without shared liquidity.
Yeah, we mentioned when talking with Paul, Jack, just, there were a lot of smaller fantasy sports operators at the beginning who had just made no sense to be regulated in Ontario only, because it would have been such a small business, and the associated costs, as you point out, it just would make no business sense to go down that path.
Yeah, I mean, and the bigger operators decided, again, they have a registration in Ontario, but they're more interested in providing sports betting and iGaming, and not interested in providing DFS only to players in Ontario. So really, there's no business case, or at least there doesn't seem to be a business case for anyone now.
Hey, Jack, I know you've been going through some of the documents, and there was, I guess, I don't know if hearing's the right word, but the court gathered back on July 5th, and we're doing this interview on Wednesday, July 24th. But one thing I wanted to ask you about was there's a group of organizations that are interested in being involved in this case, and sorry, I'm trying to remember the judge. Judge Catherine Van Rensburg. She heard back on July 5th that there are several, I guess, interveners, they're called, and that included in that is the Canadian Gaming Association, Flutter Entertainment, the Mohawk Council of Kahnawà, NSUS Group, and NSUS Limited, and then interesting, I guess a little more interesting to me is that the Atlantic Lottery Corporation, the BCLC, Lotteries and Gaming Saskatchewan, and the Manitoba Liquor and Lotteries Corporation, which effectively make up the Canadian Lottery Coalition, along with the Attorney General of British Columbia, have also taken an interest in this case. I just wondering, can you provide some perspective or insight on that?
Yeah, I mean, Steve, there's a few reasons why this case is interesting, and some of those reasons are the traditional. I'm really looking forward to hearing, lawyer nerd, really looking forward to hearing the argument that's put forward by Ontario. I have a good idea of what they're going to do, and I'm happy to talk about that later if it's something you're interested in. But I'm really looking forward to hearing the argument and hearing how it's received by the judge. That's sort of your typical interest. But what's something that's atypical about this case, something that's fascinating to me, is that the interveners, specifically the BC Attorney General and the Canadian Lottery Coalition, have filed records with the court. I mean, they filed for intervener status, and they've been granted intervener status. They've also filed these records with the court that have just a bunch of information that I don't really understand what's going on. So when they filed they filed the information. What actually happened? They filed the information. It had a bunch of documents and info inside, and the Canadian Gaming Association filed a motion to keep that information confidential for a variety of reasons. And the most recent decision of the court was to say, no, it's not confidential. And they released all of the information. And you look at what's in here, and I had to double check on the calendar that it wasn't December 23rd.
And again, my understanding is that I think the Lottery Coalition, there's about 700 pages of documentation, right, Jack?
Yeah. Well, Steve, you were supposed to ask me why would you say it was December 23rd? And then I say, because it reads more like a Festivus airing of grievances than a motion record. So some of my prepared comedic material. Anyway, so it reads like an airing of grievances. It's the BC Attorney General's motion records it's 350 pages of, you have grievances about operators registered in Ontario offering services to BC players. You have a problem gambling prevalence study from 2014. You have a 2020 another 2020 online gambling prevalence study. And then you have an expert report from Nelson Rose Nelson's great, but this report doesn't address the specific legal or practical arguments that Ontario will be raising. It's just a broad description of the challenges of having pooled liquidity across jurisdictions. So that's the BC Attorney General. The Canadian Lottery Coalition is, I mean, it's 431 pages of evidence that just shows operators offering services to players in other provinces. Here's Exhibit A of an ad on the boards of a rink that shows this operator offering its services that offers services to British Columbia players. Here's an ad, and it's just pages and pages of this, and I'm not sure why, other than, I mean, clearly they're doing it to disrupt or confuse the proceedings, because in terms of shared liquidity, to me, it's not controversial from the perspective of, and look, I'm not an expert in this area, but I just don't see it as something that's controversial with respect to increasing problem gambling or the prevalence of gambling. I mean, I think there's a lot of valid arguments that, since the Ontario market has launched, there's been an increase in the prevalence and the normalization of gambling. And I think that's a valid criticism and a valid concern. But with this liquidity reference, I don't see how substantively what kind of opposition you would have to it. I mean, legally, that's a separate issue, whether you can legally offer where you can have shared liquidity outside of Canada. That's a legal issue. But to have this type of opposition, it's surprising. And I mean, if there was a time to use this type of strategy to convolute something that was happening, why not do it during the conduct and manage reference or the conduct and manage application that happened a few months ago? Because if the conduct and manage situation wasn't successful, that would have completely torpedoed the Ontario iGaming industry.
And I assume that there's the same type of motivation for the Mohawk Council of Kahnawà, Jack, to be an intervener in this case as well. Yeah,
I'm not sure what specifically they're doing. I mean, the motion materials or the record that they filed, I mean, it's just not I don't know what's going on there, but it's really what's happening with the Attorney General of BC and the Canadian Lottery Corporation. That's really just an interesting approach where they are. I mean, it's a funny situation, and I'm really looking forward to seeing what happens.
Hey, Jack, just for the record, on December 23rd too, I don't start thinking about Festivus or Christmas till December 21st, so that's why that reference can completely whiz by my ears. So, hey, going back to Ontario again, and you mentioned you love to provide more context on Ontario, and so I'll let you let her rip on that.
Yeah. Okay. So, legally, Ontario's argument. I mean, let's try to break it down into 5 steps. I mean, you have an extremely knowledgeable audience, people coming from different backgrounds. Maybe not everybody has a legal background. I'll break it down, and then you can edit as you see fit. So 5 steps. I mean, the first step is to just note that 207(1)(a), which is a section of the criminal code that allows the provinces to conduct and manage gaming in that province, or in conjunction with other provinces. So the argument here is that the phrase "in that province" that's used should be given the same meaning as the phrase "in the province" that's used in different sections of Canadian legislation, specifically in the Constitution Act, in areas that are are exclusive provincial legislation, like property and civil rights in the province, and all matters of a merely local or private nature in the province. So the takeaway is, let's treat the phrase "in that province" in the relevant section of the code the same as we treat "in the province" in different pieces of legislation. That's the first part. So if we do that, and "in that province" is the same as "in the province," this is why everybody loves lawyers, the next step is to apply a test called the real and substantial connection test. And this is a test that originated it was originally from a 1985 telephone fraud case where it was a guy named Libman. He was in Toronto. He made a number of phone calls from Toronto, but all of the victims were in the United States. So he tried arguing, no, this took place outside of Canada because the victims were there. And the court found as long as there was a real and substantial link between the offense and Canada, the act can be considered to have taken place in Canada. So there have been some subsequent refinements, but the idea is that the focus is on actions committed in the province. So Ontario, this is the third part. Ontario is going to use this real and substantial connection rationale to argue that because iGaming Ontario, the gambling, has a real and substantial connection to Ontario, it's taking place in Ontario. Players are participating in Ontario in a lottery scheme in that province. That's the third step. Again, this is my interpretation based on the materials that I've reviewed. I haven't been involved in any way in this. Step 4 is Ontario will then argue that 207(1)(a), so that's the section of the criminal code that allows provincial governments to conduct and manage gaming. It operates to restrict the provinces from conducting and managing a lottery scheme in other provinces without the province's permission. So it's a restrictive provision. It says you can't operate in other provinces unless you have the permission or you're working with the other provinces. What it doesn't do is place restrictions on persons outside of Canada. Finally, the fifth step is there's a case from 20 years ago called Earth Future Lottery. And this wasn't a 207(1)(a) case, which is the province conducting and managing. It's a 207(1)(b) case, which means it's the charities receiving a license to conduct and manage gaming. So this was a PEI case and looked at the legality of PEI licensing charities to offer lotteries from PEI. So here you would get a license from PEI. You had you would run a lottery, a raffle, and you would offer it from PEI to the rest of the world. And there was a reference on this. Court said you can't do it. And there's some interesting quotes from that case from the judge that may have to be overcome by Ontario. So one is Section 207 does not permit conducting, managing, or operating a lottery scheme outside the province. That's one quote. Another is that Parliament's purpose in enacting Section 207 was to create a narrow exception legalizing certain provincially run or licensed lottery schemes. It did not intend 207 lottery schemes to be conducted, managed, or operated outside the borders of the province, running or licensing them, except with the consent of another province. So they are going to have to overcome. There are ways to do it, and they may be able to do it, but they are going to have to overcome the decision in Earth Future Lottery.
Hey, Jack. So we know that the Attorney General of Ontario, Doug Downey, he's supporting the marketplace in Ontario here. He'd like to see them be able to offer expanded gaming to FanDuel customers that you point out, or DraftKings, or the other operators who are offering online poker. What do you think the chances that the province wins this case?
Well, okay. So first of all, I mean, I think they've got a great team in place, and not only on the Ontario side, but they've also got George Swaney, who's the VP of Regulatory Affairs for Flutter. He's a longtime AGCO guy. He was the chief strategy officer, and Flutter operates, not only do they have a PokerStars, but they also offer DFS through FanDuel. So, I assume will be able to demonstrate that it'll be possible to comply, which is really helpful. And Flutter also has Scott Hutchison as their counsel. So Scott he will easily be a first ballot inductee into the Canadian Gaming Law Hall of Fame. He's been doing it forever. He's amazing. He's a lawyer that I have a lot of respect for. But as far as the likelihood of success, much like Cinderella's carriage at midnight, this is where I turn into a pumpkin/lawyer and start giving maybe some non-answer answers. But I will make three comments. One, which I said already, I understand the opposition to the expansion and normalization of gambling that's taken place here. I think there are some sincere and legitimate concerns, but I don't think that there should be, again, not from a legal perspective, but I just don't see any issues with respect to opposition for shared liquidity. I just don't see it. As far as success, I mean, my personal opinion is that the court's attitude towards 207(1)(a, so again, allowing the provinces to conduct and manage gaming, it's been highly deferential. It's been, very much like the court's position is, just give me something here. Just give me something that I can use, some legal argument that I can run with. I mean, they want to be deferential to the province. So I could see the court agreeing with Ontario's position that, even if liquidity is pooled internationally, under certain circumstances, the gambling could still be conducted and managed in Ontario. But on the other hand, I mean, the third and final point is you do have other provinces actively trying to sabotage Ontario in this situation. So it'll be interesting to see how it plays out. And I'm wondering why, if you were going to try to do this, why wouldn't you do this with the Kahnawà application with respect to conducting, managing gaming? So I don't know. It's interesting as a gaming lawyer. And somebody who is invested and interested in the space in Canada, I'm just excited to see what happens.
Yeah, I'll just mention, Jack, for our listeners and viewers of the podcast, that we'll include on when we put this podcast out on Substack, we'll include links to some of the documentation around this case, because there is some good reading, and it includes the documents submitted by the various interveners. And when we were doing some research before the podcast, we also found there's a sworn affidavit from George Sweeney, who Jack mentioned earlier. So we'll try to make sure we include a link to George's affidavit as well. Hey, Jack, just on the whole provincial federal dynamics, I think I just want to mention there's a story on a website today from that interviews Senator Marty Deakin on Bill S-269, and that's Senator Deakin and another senator kind of leading the charge for a national framework on sports betting advertising, and it's actually the publication is Open Access Government, and the Senate continues to debate Bill S-269. Just want to get your legal opinion, counselor, on how realistic this is, or again, is this a complicated issue because of the language in the criminal code?
Yeah. Okay. Well, first of all, Steve, thank you for asking for my legal opinion, because it's a perfect opportunity for me to mention that nothing that I've said on this podcast should be considered legal advice. So thank you for the reminder there. The second thing is, and I'm sorry, just to go back to the case that we were discussing, not substantively, but you mentioned that the record here, it's incredible. If you're a Canadian gaming historian, don't walk to the Ontario Court of Appeal website and look at the motion record. It's got historical debates from the 60s, the 70s, like from the late 50s until the 80s, in terms of what the debates were around the expansion of gaming. It's got the confidential iGaming Ontario operating agreement and policies and procedures. I mean, this is part of the public record now. There's some minimal blacklining here, but it's there. And then you have hundreds of pages of examples of Ontario-based operators accepting players from the rest of Canada, the advertising outside of Ontario. It's amazing. And thank you for putting a link up. And I encourage you, if you're interested in the Canadian gaming space and even the legal space, go look at the motion record. It's really fascinating. As far as the specific legislation, I mean, and this is definitely not legal advice, but you had Amanda Brewer on your, I mean, you always have Amanda Brewer on your podcast, and she's great, but you had her specifically talking about Bill C-269. And I mean, I honestly, I was just nodding my head in agreement. I agreed with everything that she said about some of the concerns about the legislation. I mean, how do you single out a specific type of betting? How do you implement this framework? So I don't know how you have a ban only on sports betting. What about iGaming? What about lottery? And it's not a ban, but establishing a framework. I mean, what is the point of having a framework that's limited to sports betting? On top of that, gambling, really, yes, it's in some ways federal and provincial, but I mean, it's a provincial issue, and should, from a legal perspective, be dealt with provincially. Now, whether a national internet gaming mandate would have been a great solution to some of the issues that we're seeing now, I mean, that would be great, but that's not what happened. And I think that I mean, this is really not. It's really not something that should be a concern. I mean, the advertising spillover in other jurisdictions, I agree that's an issue, but there should be other mechanisms in place to address those.
Yeah, it's a great thought, Jack, and it had me thinking about what's going on in the U.S. right now as states, states try to, or the industry tries to get iGaming expanded, and I think that's one of the reasons why there's envy about the Ontario model, because I think there's legal iGaming in 7 or 8 U.S. states right now, and operators are pushing hard, and I think there's a lot of regrets or thinking that if there wasn't a national regulated framework for gambling in the U.S., that things would be so much easier. And I think that's, you're saying the same would be true of Canada, which makes sense. Hey, last question for you, and you've been on the show a couple of times, but just would like to get your thoughts on and the conversations that you have with your clients on the regulated gambling industry in Ontario. And as I mentioned to Paul, I mean, this is still a very immature marketplace. And we had Martha Otten on the podcast back in June during the Canadian Gaming Summit and talked about kind of that sprint to get the market up and running in April 2022. But I think the evolution of any kind of regulated industry is what keeps people like yourself busy and adding up those billable hours. But what is there anything that's top of mind with you right now, or just some general thoughts about what you've seen in Ontario now that we're 2.5 years into the regulated industry here?
Yeah, I mean, yes, the market is crowded, but there is also always room for innovation, and we are still going through the application process. I mean, we have multiple operators and suppliers that we are currently going through the application process with, and gaming is constantly evolving. And as it evolves, you have people coming in with new or slightly different ideas and ways of presenting those ideas, and that can make a big difference. Realistically, right now, you have a few operators with the majority of the market share, but it's a huge market here. And if you're able to find your niche, you don't need 20% of the market in order to be profitable. So there's a lot of room here.
Jack Tadman is the managing partner of GME Law. Jack and his colleagues have a really good blog. So if you get a chance, go to gmelawyers.com, and Jack and his colleagues weigh in on not just what's going on in the gaming industry, but what's also going on in the entertainment industry as well. So it's always some good reading there. You can also find Jack on LinkedIn. Hey, Jack, great to have you back on the show and get your insight on this court case. And enjoy the rest of your summer, and we look forward to speaking with you again in the fall.
All right. Thanks, Steve. Really appreciate it. Thank you for having me.
That's it for this episode of the Gaming News Canada show. Again, we say thanks to Jack Tadman and Paul Burns for being our guests. You can find this podcast on gamingnewscanada.ca. You can also find us on Substack and also watch the podcast on the Gaming News Canada YouTube channel. Again, thanks everybody for joining us, and we'll see everybody again real soon.
Thank you for listening to the Gaming News Canada show. Sign up for our newsletter at gamingnewscanada.ca. Follow Steve McAllister on LinkedIn. Message Steve if you're interested in being a sponsor or featured guest.